All right. Criminal courts frequently rely on accomplice witnesses to testify regarding the role of an alleged co-conspirator in a crime. Testify regarding the role of, okay. And jailhouse informants, witnesses who provide testimony based on information obtained while incarcerated for prosecutorial information. So we have these two things that we frequently rely on. Typically, the testimony provided by such cooperating witnesses includes information garnered through the witnesses' conversations with the accused, which can include a purported confession of the crime. Okay. So essentially, what they testify comes from talking to the people that did the crime.
Mm-hmm.
So far, I'm feeling an informative passage, but we will see. Information from a cooperating witness is often provided in exchange for a reduced sentence or some other incentive. This kind of inducement creates a situation that is highly conducive to evidence fabrication on the part of the cooperating witness. In fact, one recent study concluded that lying informants are rarely prosecuted and therefore have much to gain and little to lose by testifying falsely. That's awful. So like you can sit like, I believe it, but that's what goes on. But still, you shouldn't be allowed to lie and potentially bring down other people. While courts have recognized the unreliable nature of evidence obtained through bartered testimony, they have held that safeguards are in place to adequately protect the accused against a conviction based on false testimony. So saying like, we recognize that it's unreliable, but we have safeguards in place. Well, then why is it still unreliable is my question. These safeguards allow effective cross-examination of a cooperating witness and enable the jury to consider a witness's motivation. Okay. However, these safeguards, I feel like our author's opinion is really coming in here. However, these safeguards do not always provide protection. There are cases in which prosecutors merely imply to cooperative witness that they will receive an incentive in exchange for testimony. In such cases, the exchange between prosecutor and witness does not have to be disclosed to the jury. Sneaky.
I don't think I'm understanding this part.
Okay, so we're saying that so the courts recognize that the evidence that we get from these type of witnesses um, can be unreliable, but they think that they have safeguards in place to prevent that. And their safeguards are like allowing the defense attorney or to cross-examine that witness. So that's one defense guard. And their other defense guard is that the jury is allowed to know that they're receiving a deal to testify. But our author comes in and says these safeguards don't always provide protection. And that's because like there's sometimes where the prosecutor will just tell the witness that if you help me, like I'm going to give you this incentive. But since he just implies it and doesn't guarantee it, the prosecutor doesn't actually have to disclose it to the jury.
Mm.
So it'd be like me saying like, if you do this, I will help you out, but I don't guarantee it. I'm just kind of like allude to it. So I don't actually have to disclose it. Interesting. In addition, psychological research on confession testimony, confessions obtained by investigators directly from the accused, reveal further problems with bartered testimony. Now we got more problems with not only do we have these with our other witness, now these are our informants. This research indicates that jurors give undue weight to confession evidence when rendering guilt decisions.
So what is that saying?
This interesting research on confession and confessions obtained by investors directly from you. This in it that jurors give undue weight, so an unfair amount to confession evidence when rendering guilt decisions. So I guess like we give too much credit to the confession whenever we are trying to render a guilty decision. But I think I need to read more to like specific. Is that saying that they are more likely or less likely to convict them? This effect is especially notable in cases where jurors are aware that a defendant has been offered an incentive in exchange for a confession. Oh, maybe it's the opposite, like where like maybe it's like that even though the person's really guilty, it's like that double manipulation where since the person like got the confession, had like a motive, that they're like less likely to believe the guilty verdict and they're more likely just to say not guilty no matter what, even if the person really is guilty.
Oh.
I don't know if that's where it's going, but that's what I'm thinking. This is particularly relevant here because if people have difficulty realizing the effect that an incentive can have on a defendant's behavior, they may also fail to realize the effect that an incentive may have on a cooperating witness's behavior. I don't know what this isn't relevant here because if people have difficulty realizing the effect that an incentive can defendant's behavior. The effect that an incentive may have.
Who is the defendant?
Whoever committed the crime.
In this case, okay.
Yeah, like in just general. So are aware that a defendant has been offered as an. Oh, I didn't read a sentence. I'm sorry. This effect is especially notable in cases where jurors are. This effect is especially notable in cases where jurors are aware that a defendant has been offered an incentive in exchange for a confession. So they gave the like for some reason they gave the defendant a deal to confess. The effect that incentive, they may also fail to realize the effect that incentive may have on a cooperating witness's behavior. Okay. A common psychological thing may account for jurors' superficial examination of confession evidence. Studies show that people tend to explain the behavior of others in terms of internal dispositions or attitudes as opposed to external situation factors. So we explain the behavior of others in terms of like our own attitude. In one study, regardless of whether confession evidence was obtained via negative pressure, threats of worse treatment and or harsher punishment, or positive pressure, promises of better treatment and or leniency, mock jurors viewed a confession as evidence that the defendant committed the crime because only a guilty person would confess to such a crime. Oh, so the same logic can be applied to a testimony of cooperating witnesses. Jurors may presuppose or jurors may assume that a compliance witness and jailhouse informants offered their testimony as an atonement rather than deducing the external factors made it expedient to give the testimony. So they think that it doesn't matter if there's external factors that are pressuring someone to get this, or like they just think like only a guilty person would ever admit to being guilty, and that's not the case, right? Like someone might confess because they were told that if you don't confess, like you're gonna go, you're like no matter what, your jury is gonna say you're guilty and you're gonna go to jail, and we're gonna like give you awful living conditions. So you might as well just confess and get better living conditions. So what do you think is the what do you think is the main point of this passage?
That the use of like witness testimony has like the potential to be unreliable, especially if like the witnesses are provided some incentive for testifying like against the defendant. And it also kind of talks about the fact that like despite like cross-examination, if like jurors are aware that these incentives like exist, that it will affect the decision they make.
Yeah. I was trying to see if there was. Okay. So start with A.
Evidence obtained through coercion, whether that coercion results from positive pressure or negative pressure, can never be regarded as reliable. I don't like that one because I feel like that's, well, I don't know. I don't really like that one. I feel like it's really like big to say can never be regarded as reliable.
Yeah, I don't like that one either. All right, what about B?
Numerous considerations suggest that courts' reliance on the testimony of accomplice witnesses and jailhouse informants may result in convictions based on false testimony. I would like to keep that one.
Me as well. All right, what about C?
Studies show that jurors give undue weight to confession testimony, a fact that may be explained by people's general tendency to ignore situational factors in explaining the behavior of others. I don't know if that's because of the tendency to ignore situational factors, but I don't know. I guess I keep that one.
Okay. Wait, D?
I know I picked this one. Traditional legal arguments offered in support of permitting the testimony of accomplice witnesses and jailhouse informants are based on a set of assumptions that numerous studies cast doubt on. Now looking at this, I don't really know if these like were offered in support of like with assumptions.
Well, what is the assumption that the fact that we're allowed to permit the testimony of a compliance witnesses and jailhouse informants are based on? What are the assumptions that that's based on? Like people that think these are okay, why do they think they're okay?
Because of the safeguards that are in place.
I would say that. And do the numerous studies cast doubt on those safeguards?
Is the only safeguard they talked about just like them being cross-examined and the jurors being known? Yeah, I mean, that's why I thought that they.
No, I don't think this is a terrible answer.
I just don't know why it's wrong.
Traditional. I don't think that this paper was written to share okay, so this goes back to the purpose of this paper. Is the purpose of this paper, or the person writing it, to show us that studies cast doubt on allowing this to happen? Or is this paper more about the negative things that happen because we do use these kind of testimonies?
Oh.
I think
Yeah,
it really comes down to the why.
Mm-hmm. That makes sense.
Okay, I do think D is tempting though. All right, but what about E?
There is substantial evidence to indicate that the testimony of accomplice witnesses and jailhouse informants is heavily influenced by incentives offered by the prosecution. There is substantial. No, I don't like that one because the whole paper isn't about like how they're affected by like the incentives.
Yeah. And do we have substantial? Like, what is substantial? That's a very strong word.
Yeah, no, I don't believe we have substantial evidence.
Awesome. And then let's go back to C for a second.
Studies show that jurors give undue weight to confession testimony, a fact that may be explained by people's general tendency. I mean,
so I think where part of our problem here is both of these are supporting our main idea. See, Andy, like this is just a portion of our paper that jurors, so part of it, we have two issues are going on, right? One are informants, and one of them are like jailhouse informants, and one are like our accomplice witnesses or whatever. And so one of our like D is kind of just a fact that supports this idea that so we lead to people that may result in false convictions. And so as well as C is that the jurors is only this part is like only talked about in passage 3. Like, when it comes to main point, we should be able to pick something out of every paragraph that supports it, where we can't find something that supports C and D in every single paragraph. It's too narrow.
So then it would be B.
Yeah. Do you see that?
Mm-hmm.
Cool.
And C and D actually like do support B.
Yes. And then without B being too like out of scope. Like it's not too broad, but like why, and then it comes down to main point, why did this author write this? And the author completely wrote this because, hey, these testimony, like we don't have the proper safeguards in place, and this ultimately can lead to people falsely confessing, and our jurors don't know, like, to even like they just take a confession as a confession, and that's it.
Mm-hmm.
All right, did you miss 16 as well?
Mm-hmm.
All right, so which of the questions is explicitly addressed? All right, go ahead and start with A.
Do jurors give the same weight to confession evidence provided by a cooperating witness as they do confession evidence provided directly by the defendant? I don't like this one because they didn't talk about like comparing those two
Yeah,
types of confessions.
they say they give like an undue weight to the cooperating witness, but that doesn't mean that it's the same. Excellent. What about B?
To what extent are prosecutors and investigators limited in their ability to offer incentives to accomplice witnesses and jailhouse informants in exchange for testimony? I did not like this one because I felt like it really didn't talk about like even the incentives exactly offered, especially it didn't talk about like the limitations they have on the incentives.
Excellent.
And then C, is the barter testimony of an accomplished witness any more or less reliable than the barter testimony of a jailhouse informant? I know I crossed that one off. I did not like that. Because it's not comparing those two type of like witnesses.
Excellent.
D, how common is the prosecution of cooperating witnesses who knowingly provide false testimony? I don't want to cross that one off, but I don't know where that is in the passage.
Okay.
And E, to what extent do jurors vary in their ability to discern when a witness is lying? I don't think, I don't want to just get D by default, but I don't like E because it's not saying, like, not talking about the ability of jurors.
So what would you do at this point if you were down between D and E?
I would do Command F.
Excellent. And what would you Command F for D?
Um, maybe like false testimony.
I agree. What would you Command F for E?
Um, lying.
I would probably do like lying or jurors. That's what I'm thinking.
I feel like jurors is in a lot of the thing.
Yeah, but I'm nervous that lying like might not be. I would be nervous that lying, like there's so many synonymous words for lying.
True.
So I happen to know that this one is in the second one. I just remember this because I got mad at it, where I was like, one study concluded that lying informants are rarely prosecuted and therefore have much to gain and little to lose by testimony, which I know that's not like an exact percentage, but for D, how common is the prosecution? So it's asked like, how often do we prosecute those that provide false information? Rarely.
Mm-hmm.
Cool. So that's why it's D.
That makes sense. For some reason, I picked.
A is the trap answer.
I picked A.
Yeah, it's the same way. It's too strong. Awesome. All right. What was the other one that you missed?
20? I missed. I missed 20 and 21. So the first two and the last two.
The author mentions the research on confession testimony, the fourth paragraph, primarily in order to. All right, so 1, 2, 3, 4. In addition, psychological, okay, so why do we include this research? I feel like this was the hardest part of understanding the the passage.
Let me read it really fast. Defendant's behavior. I think it's important that the last line says this is particularly relevant here because if people have difficulty realizing the effect that an incentive can have on defendant's behavior, they may also fail to recognize the effect that incentives may have on cooperating witness behavior.
Okay, so whenever we go back and it's talking specifically about, so why do you think that, okay, so you're right, but why do we mention the research on confession testimony in particular? To show what?
That it can lead to like false accusations.
Why can it lead to false accusations? Or because what does this show? Like, what does this research show us?
Um, oh, it's the fourth. Oh, I was looking at the bottom one. Jurors give undue weight. Evidence when rendered. Wait, which is that the right paragraph?
Yeah, it's the one that says in addition.
Oh, because then it tells us that it gives the jurors, or like that the jurors give undue weight to confession evidence.
Like, it's to show us, like, this research shows us just like how the jury isn't able to actually take in other information, like a guilt. Yeah. All right, so let's go down to our answer choices.
A, reveal a potential problem for the author's analysis. I don't really think that it reveals a problem for the author's analysis because I think the author is analyzing like this fact.
I agree. Yeah, it's not, that it's definitely in favor of our analysis that there are issues.
Mm-hmm.
All right, what about B?
Make an unfavorable comparison to a study cited earlier in the passage. I don't think so.
Nope, we don't do that.
C, justify a conclusion regarding jurors' treatment of evidence provided by cooperating witnesses. I'd like to keep that.
Sorry.
D, question the relevance of jury decision making process to the issue of the court's reliance on the testimony of cooperating witnesses. I don't know if it's like influencing the jury decision making process.
Yeah, do we question the relevance of the jury?
No, I also picked D.
Like, yeah, I don't, yeah, our issue, like, we don't bring in the research to show us the jury isn't relevant when making decisions on jury makes just brought to the issues of the court's reliance on the testimony of cooperating. Yeah.
Yeah, I don't like D, even though I picked it.
I'm sorry, can I be back in 1 second?
Yeah.
I'm so sorry.